Yeah. Good morning, everyone. Sushrita, this is your interview,
Namaskar.
and we have with us Sri Gadhar Panda sir, who has 30 years of experience in Odisha judiciary. He was retired as a district judge, and after that, uh, s- uh, he was also a part of the evaluation committee of the Odisha Judicial Services. And we also with us have Sri Prabhu Prasanna Behera sir, who is the Central Government Council for the Government of India. Sir has also more than 15 years of practice experience, and I hope this interview will be productive for you. Over to you, sir. It will be a three-panel interview, starting with Gadhar Panda sir, then Prabhu Prasanna Behera sir, and then myself.
Namaskar, sir.
But where are you residing at present?
Sir, currently I'm residing in Bhubaneswar, in Nayapalli, sir.
What is the difference between residence and domicile?
Sir, residence is the place where a person is residing. It might be permanent or it might be temporary. But domicile is, sir, where a person has been registered to be there or is believed that or has been recognized to be a permanent resident of that area, sir.
Okay. What is charge under the Transfer of Property Act?
Sir, charge has been defined under Section 100 of the Transfer of Property Act. So, sir, when a debt is secured by, when an immovable property is secured by unsecured debt, sir, so a charge is created, which is not basically a transfer of property and is not mortgage in nature. So, the person in whose favor a charge is created has an interest in that property, sir.
Why a document is attested by witness? What is the purpose of attestation of a document?
So the purpose of attestation of a document is to verify the genuineness of the document and to testify that the person who actually was the executant did it within under a free consent and he was not coerced by any other person or he was not asked to do that under any other undue influence. And also it is a testification to the fact that the executant and not and no other person has signed the document, sir, or conveyed the document.
If the attesting witness is required to go through the contents and to ascertain that there is no fraud, no consent, free consent is there, if a such an attesting witness is required to do so,
Sir, the moment a person attests a document, he is already under this surety or under this assurance that the person who is the executant has done this under this free will, sir. Either it may be conveyed by the person verbally that I have done so and so under my free will, or it can be made by under an acknowledgement, sir, the by the executant.
document is defined in the Evidence Act. There is also a definition of document in the Indian Penal. But
Yes,
what is
sir.
the difference between those two definitions?
Uh, yes, so there is a minor difference. I believe in IPC, the definition of the document is a little far more inclusive, but I'm sorry, sir, I can't recall at this moment.
What is redemption?
Sir, when
Redemption
a
of a
mod,
mortgage.
yes, sir. Sir,
Okay.
when a yes, sir. Sir, when a mortgager mortgages his property, he transfers only a part of the interest in such property. Even after transferring the mortgage, he still has some residuary interest in that property. And by paying the debt amount, he can recover this property. This is called a right of redemption, which has been provided under Section 60 of the Transfer of Property Act, and it's a equitable remedy, so equitable rights.
If in a mortgage, property is partially transferred.
Yes, sir. Mortgage is the transfer, is not an absolute transfer of property. Some interest in the property is transferred, and the residuary, that is the ownership of the property, resides with the mortgagor, sir.
Then what is foreclosure?
Sir, foreclosure is the opposite of that of redemption, in which the mortgagee has a right to apply to the court so that the mortgager cannot redeem that mortgage property from the mortgagee, sir.
What is vested interest?
Sir, when a property is transferred, uh, it can be divided or classified under two heads as per the time of the interest is accrued. Sir, on that basis, an interest may be vested interest or contingent interest. Vested interest has been provided under Section 19 of the TP Act, which says that when a property is conveyed and the time of accrual of the interest is either not mentioned, or it is mentioned that it shall take effect immediately, or it is mentioned that it shall take effect on the happening of a certain specified event which is must to happen. In that case, we can say that it is a case of vested interest, which is a present fixed right, and it is heritable and transferable in nature, sir.
When a suit is to be disposed of at the first hearing,
Sir, when the defendant acknowledges or admits whatever the issues have been brought out and pays the money or does or admits whatever has been alleged by the other party, in that case, sir, the suit can be disposed as, at the first hearing.
on what basis issues are framed in a civil suit?
Sir, issues are framed on the basis of where one party alleges one thing and the other party disputes to the other thing. So the subject matter, when that is in dispute, that is framed as the issue, sir. It's not charge, it is the issues that are framed in the civil code.
Okay. Is there any provision in the civil procedure code for filing a suit in public interest?
Sorry, sir, I'm not aware about it.
What is cheating?
Sir, Section 415 of the IPC defines cheating. Sir, by cheating, a person uses fraud and undue practices so as to make another person get into a contract, or to ask or to manipulate him in such a manner to give consent for a certain thing, which the person giving consent would not have given consent had he known the true nature of the fact, sir.
What is mischief?
Sir, mischief is when an act that is done intentionally or with a knowledge that it is likely to cause any kind of damage or injury to the public or destruction of anything, or which reduces the quality or the value of a thing, is said to commit mischief, sir.
Whether character is relevant in a criminal case?
Sir, previous bad character is not relevant. That is the general rule in criminal case. But previous good character is relevant in criminal case. However, sir, there are exceptions where the previous bad character seems to be relevant in criminal case. There are three exceptions. The first is when that character is in the fact and issue, and secondly, sir, when evidence is given that a person has good character, so in order to rebut that, bad evidence of bad character can be given. And finally, sir, when previous conviction is essential for deciding the enhanced punishment under section 75, in that case also, sir, previous conviction records and bad character can be given in evidence, sir.
Okay. Now you may be interviewed by other panelists, and I will give my feedback within few minutes. Thank you.
Thank you, sir. Namaskar, sir.
Namaskar. How are you?
I'm fine, sir.
Okay. So, you did your masters
No,
in
sir,
which
I'm
you
continuing.
you're
I'm
continuing your master.
continuing. Yes, sir.
Which subject?
Sir, human rights.
Human rights.
Yes, sir.
Okay. So, yes. So, are you preparing any are you preparing any dissertation in your masters?
Yes, sir. I actually submitted my dissertation in my second semester.
Which
It was,
subject?
sir, it was
What
about
was the topic?
UCC,
Topic?
Uniform Civil Code, sir.
All right. So there is a huge hue and cry regarding implementation of uniform civil code.
Yes, sir.
Right. What is your opinion?
Sir, I believe it is the need of the time, and time has come to implement the Uniform Civil Code because here, sir, the purpose is to move forward for gender justice and to promote equality, sir. And because there are many different kind of laws that are governing different kind of religions, so there are certain parts where the law cannot reach out to people because it is the custom that is actually dominating at that area, sir. So for that reason, we cannot actually help the people who are actually under any distress due to the personal laws. So if uniform civil code will be brought, so the human rights of the people can be promoted and can be properly protected, sir.
Okay. So wha- what is the requirement or eligibility criteria to be the member of a human rights commission?
Sir, for the NHRC, there is a chairman who is basically a retired Supreme Court judge, and apart from that, sir, there are members of the commission. Sir, they're preferably the retired or sitting judges of the High Court or the Supreme Court, and apart from that, there are some members who are proactively indulgent and have special knowledge and experience in the field of human rights, sir.
Is there any specific eligibility mentioned in the statute?
No, sir, I'm not aware about it.
Okay. How do you see the international human rights and the human rights issues in the current scenario for our country? Is there any specific issues where you have focused or you have studied in connection to the international human rights issues?
Yes, sir, I understand. Sir, in international human rights scenario, if we see, the scope is very broad, and they believe that that should be promoted at every cost. The protection of human rights must be done at every cost. But when we look into the scenario of India, we are but restricted by some of the impositions, and we are not in a proper way to implement in a proper manner as we have done. We have signed the various UDHR or ICCPR, sir. If we see, sir, if I may quote an example, sir, according to the UDHR and ICCPR, there is a complete abolition of death penalty for protection of human rights, sir, and they have condemned it seriously. But India, despite being a signatory to both these international agreements, has not yet done it. But so we cannot say that India, by not implementing this thing, is in any way hampering the human right of any person by imposing death penalty, sir. Because here in India, the scenario we have is the death penalty is given in the rarest of rare cases, and there are numerous checks and balances and many preventive measures so that the death penalty is not given as a course of procedure, sir. So I believe that they're complementary to each other, and we at our place are also trying our level best to implement those things. So
Okay. So, as a judicial officer, you see you are in charge of a station and you see there is a violation of human rights or basic requirement uh, of a citizen of the country is not given. You are convinced that there is a violation of human rights. Do you think you will be in a position to exercise your position and judicial post in protecting the human rights of that person?
Sir, there can be two scenarios in this case. The first is if there is a violation of human rights, sir. Sir, in this case, I can take the matter suo motu and take a complaint against it and issue process as the law requires it to be done.
What
But
is the
in the
provision?
second,
What is the provision? Provision. Is there any statutory provision which empowers a judicial magistrate to take so moto cognizance of violation of a human right?
sir, not exactly human right, but sir, if an offense is committed against a person, that is also a violation of that person's human right. So, for that, sir, the magistrate has been empowered under Section 120, subsection 1C, where he can take the complaint suo motu, sir. And sir, if the other case is concerned, that if I see that a person is not given the basic necessities to have a proper human life as he's supposed to do, I believe, sir, judicial magistrate scope is not that vast to implement such kind of things, and it does not come within the domain of the judicial magistrate. So it's a domain that comes under the case of the state, sir, and it is the state who should do that work, sir. Although I may make some, in my personal capacity, I can help that person to move to the proper authority to seek such things. But the judicial magistrate, I don't think, sir, if he has any role to play here, sir.
Can a judicial magistrate, first class, conduct investigation?
No, sir.
What about inquiry?
Yes, sir.
How?
Sir, in order to ascertain whether there is a proper issue or if there is a basis to issue the processor, in that case, the judicial magistrate can conduct the inquiry so as to move forward with the case or not. But it cannot conduct the investigation, sir, because investigation is purely the domain of the state. And as per the DPSP, sir, there must be the separation of powers between the executive and the judiciary, sir.
So, under which provision a magistrate can do the inquiry?
Sir, uh, um, sir, I believe in section 202, sir,
Okay,
of the CRPC.
okay. So, you're talking about DPSP, right?
Yes, sir. Yes, sir.
So, what is DPSP and how it is relevant? How it is relevant for protecting the rights of a citizen?
The DPSP stands for the Directive Principles of State Policy. So, when the Constituent Assembly was drafting the Constitution of India, they made a list of the fundamental rights or the rights they need to give to the citizens of the India. But, sir, they were later bifurcated into fundamental rights and DPSP. So, fundamental rights are those bundle of rights which can be specifically enforced against the state. But DPSP cannot be specifically enforced against the state. They are not justiciable, but they guide the state in formulating proper policies to make a proper welfare state and to bring out more schemes so that there can be proper development, sir. So whenever the state takes out any laws, it has to do it in conformity and in giving effect to the directive principles of state policy, sir.
Is there any link between DPSP and a fundamental rights?
Sir, according to various judicial precedents, initially there was a more inclination towards the fundamental rights, wherein it was said that where they are contradictory to each other, so the fundamental rights shall prevail. But, sir, with time, we have adopted the doctrine of constructive of harmonious construction, wherein we have to construe both the provisions properly and to give effect to both of them, sir.
Okay. Recently, there is a shift of a particular right from DPSP to fundamental right. Are you aware of it?
Uh, Sir, I don't think it is recently. Like, so far as I remember, sir, the right to education was of our DPSP, and later on
I
it
mean,
was incorporated.
recently, the definition of or the idea of recent might be differ from you and me, but however, the recent development or the latest development. Yes, continue.
Yes, sir. Sir, as far as I know that the DPSP that provided for giving education to a child there was a DPSP, but later on it was incorporated under Article 21 capital A, where it provided that free education shall be given to children from 6 to 14 years. And by the virtue of that particular right, sir, a statute was also brought out by the Parliament, the Right to Education Act, sir.
Yes. So what is the title of the act? Right to education, or is that a full stage? What is the short title of the act?
Sorry, sir, I can't recall at this moment.
Right of children for free and compulsory education. All right.
Education.
Okay. Uh, so as a magistrate, you issue a summon to an accused, right? So
Yes.
if he doesn't appear on the first date, what would be your order if he doesn't appear on that particular date?
Sir, if the accused does not appear on the date fixed in the summons, sir, in that case, I can issue the warrant for arrest and I can ask him to appear him on a proper date. But if, sir, I believe that the person is about to abscond is willfully trying to uh, uh, not take the summons, in that case, sir, I can also issue a proclamation. So by which the property of that person can be attached, and he shall be given a period of 30 days of time, within after which he should appear on a date, sir. And I can issue the warrant and proclamation either simultaneously or one after the other, sir.
So what is the principle of natural justice?
So, principle of natural justice is a very intricate and very fundamental principle of the jurisprudence, sir. It says there are certain principles that that must be present in every judicial proceeding. The first being said that one cannot be the judge of its own case, and the second being said the principle of audio altrum patum, that no person shall be left unheard, and he must be given his share of speaking before he is given any kind of sentence or anything is passed against him. So,
Okay. So what is your idea about hierarchy of civil court and criminal courts? Do you have any idea? Yes.
sir, if we start from the topmost court, that is the Supreme Court, but it has appellate criminal jurisdiction as provided in the Constitution and CRPC. And below that, we have the High Court of the concerned state. In some cases, sir, there are original jurisdiction of the High Court in criminal cases. But in the other cases, it's mostly the appellate criminal jurisdiction. And below that, sir, we have the Sessions Court. So in the Sessions Court, we have the Sessions Judge, and we may have one or more additional session judges and assistant session judges. And below them are, sir, the Chief Judicial Magistrate and the Judicial Magistrate First Class, the Judicial Magistrate Second Class. And, sir, if there are some special kind of cases, then certain Judicial Magistrate First Class and certain Judicial Magistrate Second Class may be designated as Special Judicial Magistrate First Class and Special Judicial Magistrate Second Class. And sir, so far as civil court hierarchy is concerned, sir, again we have Supreme Court at the top, which has the appellate civil jurisdiction, and below them we have the concerned high courts, and below them we have, sir, the district courts. So in district court we have the district judges or the additional district judges, and below them we have, sir, the civil judge senior division and civil judge junior division.
Okay. All right. So there is something called cognizance, which is being taken by the concerned magistrate. What is a
Yes, sir.
cognizance?
So cognizance has not been defined in any statute or code, but it can be said that cognizance is the time where the judicial magistrate or the judge applies his judicial mind to a case. So by taking cognizance, sir, he sees whether a prima facie case is made out or not, and on the basis of that, he can issue the process, sir.
Okay. Thank you. Thank you.
Thank you so much.
Sushrita,
Thank you.
please tell me what is the nature of Indian secularism?
That the nature of Indian secularism is very broad and inclusive. Here, the state does not take part or interfere in the matter of religion, nor does it allow the religion to take part in the state matter. However, sir, the state has a power and duty to interfere in the religious matter where the case is concerned about public safety, health, and other policies, and if it in any way affects the fundamental rights provided in Part 3 of the Constitution, sir.
Okay, okay. Can you tell me what is the procedure of creating a new state?
Sir, I do not remember it properly, but if I may be given a chance to.
Yes, yes, yes. Tell me.
Sir, for the creation of new state, the concerned state that is to be bifurcated or from which the state has to be made, that has to make an application or it has to let the parliament known about it. And sir, after the parliament considers it just and fit in that case, the assent of the president is required, and after the assent of the president is taken, sir, then a new state can be formed, sir.
Okay, okay. Can you tell me what do you understand by partly preliminary and partly final decree?
Sir, it is a type of decree where a part of the decree is it is called part preliminary decree, and the other part is called the final decree. So, sir, these decrees are passed in cases where the matter is not finally disposed of, but for the time being, a preliminary decree is passed so as to render the court a proper position to pass the final decree. For example, so if there is a dissolution of partnership firm, in this case, the court can actually can pass a preliminary decree to know which partner has how much shares or which partner is to get how much. An inquiry about that is to be made by any person. That is a preliminary decree. And after the matter is completely adjudicated by the concerned judge, so the final decree is given to give effect to the preliminary decree or any additional and ancillary matters. So.
Normally, when debt becomes time barred, the court of law will not help you in getting it back, right?
Yes, sir.
But there is an exception to this. Can you tell
Yes,
me
sir.
what is that?
The Section 25, subsection 3 provides for the exception to this case. So
25
here,
of?
if Contract Act, the Indian Contract Act, 1872. So in that case, if the debt is time barred and the person who owes the debt acknowledges that in writing and promises that he shall pay that by signing an excess, and that can be enforced by the court, sir.
Section 27 talks about adverse possession,
Yes, sir.
right? Can you tell me what is the time limit? What is the time limit that is given for a government, for a suit against a government, I mean, for a property of a government to be in the possession of someone, for it to become I mean, to come under adverse possession and he can claim a right under it?
So 30 years.
Where is it given?
Sir, sir, it's given in 25 and 25 of the uh, Limitation Act. So
25 talks about easement. It does nowhere talks about the adverse
I'm
possession.
sorry, sir. I'm sorry, sir. It's provided in the schedule. I can't remember the article number.
Okay, okay. Uh, can you really call surrender a transfer?
The transfer means conveyance of rights. So where a transfer takes place, so a person relinquishes one's right, and at the same time, that right is passed on to another person. But in case of surrender, sir, a person simply relinquishes one's rights, and no new interest is created in favor of any person. So this cannot be called as a transfer.
What is a detinue? What is a detinue?
Sir, a person who is detained is called detainee.
No. Okay. What is a subrogation?
So, subrogation means when a person subrogates another person or steps into the shoes of another person, sir. So, it is basically made in mortgages. So, where a person pays the debt amount to the mortgagee, in that case, sir, the person who is paying the debt amount subrogates or steps into the shoes of the mortgagor, sir.
Okay. What's an Anton pillar order?
So, could you please repeat?
What's an Anton pillar order? Anton pillar.
Sir, I do not remember it properly, but if I may be given a chance to
Yes.
try the answer.
Yes,
Sir,
try.
I believe anti-pillar orders are given in case of infringement of copyrights, where the person who is seeking for that order believes that the other party is about to commit any infringement of any copyright relating to cinema or movie, and the court being satisfied of that grants an injunction against it. That is, I believe, is called anti-pillar order.
That's more of a John Doe order, not
John
an.
Doe.
Okay. Okay, no issues. Can you tell me when amendment cannot be allowed?
The amendment of what?
Amendment of a pleading. I mean,
Right. Basically, amendments are allowed by the court because it's a procedural law, and the court makes all everything easier for a person to seek for the rights he's coming for the court before the court. But generally, sir, a period of 14 days is given where the time period is not mentioned to amend the pleadings. In that case, within 14 days, the amendment has to be done. Or in case the proper time is mentioned that within this fixed period of time, the person has to amend the pleading, then he has to do within that period of time. If the person fails to amend his pleadings within the fixed period or within that 14 days period, so then he is not allowed.
okay. Okay. Can you tell me why is it that a child is liable for a tort but not under IPC and contract?
Sir, for IPC, for making a child criminally liable, sir, so the most important part is the mens rea, sir. And sir, it is always presumed in case of child that there is an absence of mens rea. So for that reason, he is not made criminally liable for the want of criminal intent. And for sir, so far as contract is concerned, sir, in order to sue a party for contract for breach of contract, the most important part is the parties must be competent, and a minor is not a competent person to move into a contract. So he cannot be sued for that. But in case of torts, sir, this is an exception, and minors are liable as likely as any other major persons. It's a so in this case, sir, he's it is a civil case, and in that case, sir, for tort for compensation, we can make a minor liable, sir.
Okay. Okay, fair enough. Sushrita, can you tell me what are your hobbies?
So my hobbies include cooking vegetarian items and reading mythological books, Indian mythological books.
Vegetarian books because you are a vegetarian as well.
Yes, sir.
Can you justify the logic of, I mean, are you a vegetarian or a vegan for that matter?
Sir, I'm a vegetarian.
Okay. Can you justify the the act of eating milk of a cow by vegetarians as well, which is not which is not really your food and it is the food of the calf and that you are taking. So can you justify that while you are a vegetarian? If you're a vegan, I would understand that you are really conscious about the animal. Is it something to do with your religion?
Sir, primarily it is influenced by my religion and morals, for which I am a vegetarian, and my upbringing in a vegetarian house. And sir, so far as milk is concerned, sir, so vegetarian, we are mostly concerned with not hurting any that animals meat, sir. But so far as milk is concerned, am I audible?
Yes,
So
yes,
far
audible.
as milk is concerned, sir, here no animal is harmed or no blood is shed by that. Yes, there is a good point in the favor of the calf that we are actually taking the portion of the calf. But sir, in certain cases, the calf cannot take the whole of the milk because that is also not good for that calf's digestive system. So sometimes the cow also produces more milk that is needed for the calf, sir. So I don't believe that if any intolerance or if any cruelty is imparted by that.
Okay. Okay. What is the best dish that you can make? What is your best dish?
Sir, I can make dalma.
Dalma. Okay. 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 Thank you, Sushrita. That's it. Let's proceed to the feedback.
Sure, sir.
Sir, Gather sir, over to you.
Okay. My first question on residence and domicile. Domicile is when a person is residing permanently. Permanent residence is there. Person means the
Yes.
domicile of India, but is residing in now in USA. Sometimes every for short period we say staying, residing, and domicile.
Yes.
That charge and immovable property of one person by act of parties or operation of law. The two
Yes,
things.
sir.
By act of parties, operation of law, other than mortgage, given as security for taken as security for payment of this much. Attested, you fail to understand. Attested is a very common term in transfer property. Only they have seen the executant signing the document. This much. Regarding truthfulness or authenticity of their execution. They are not supposed to make any inquiry, fraud, coercion, etc. Two or more persons who have seen the executant signing or have received acknowledgement that they have signed in the document. Each of them must sign in presence of the executant. That is required. Then document, there is two definition of document in Evidence Act and in IPC. Any matter expressed on any substance by means of figure, letter, mark, intending to record it in Evidence Act. Here in IPC, that may be used as evidence. The same thing, the two difference. That may be document that will be used as evidence. You are recording of that matter. Mortgage, again, you are committing probably in the previously I had put this question. Only an interest is transferred. Never ownership, nothing. Mortgage is transfer of an interest in a specific immovable property as security for payment of debt. An interest you should give importance. Foreclosure, redemption is the right at any
Repeated.
time when the mortgage money is due for payment. Hello?
Sir, could you please repeat it?
Am I not,
Yes, sir. So there was
what is
so
this?
so there was an error from my end. So could you please repeat?
Which one? Document.
No, sir.
Document you
The
understood?
mortgage, sir.
Mortgage. Mortgage is transfer of an interest.
Yes, sir.
Therefore, property is transfer. As security for payment of money or given as advance by you of you.
Yes,
Be careful this. Only an interest, that word is there. Then redemption is a right of the mortgagor. At any time when the mortgage money is due for payment, the mortgagor may, by filing a suit, ask the mortgagee to receive the mortgage money and to return the mortgage property unto the mortgage. This is called redemption right. Foreclosure is a right before exercise of right of mortgage redemption. The mortgagee may file a suit to foreclose the mortgagor to remain. Probably it has been omitted now in Transfer Property Act. Okay. Vested interest, very short answer, be specific. Sometimes you become talkative. That is not required. Vested interest means an interest which has been created in favor of a person without specifying any time waiting to take effect, or it will take effect forthwith, or on the happening of an event which must happen, then that interest is vested. Then since it will disturb our first hearing when the parties are not in issue. Parties are not in issue. There is no issue immediately. Admission. Issues are framed. Basis on what? Issues are framed basing on the pleadings of the parties, document filed with the plea or written statement, and a hearing the parties. These, these are the issues. Then issues frame public interest litigations are there in section 92 and 93 of the CPC for removal of public nuisance and for enforcement of that this trust, charitable trust, appointing a trust of any two persons of the public with the consent of the court or advocate general may file. Issues where public interest, that is cheating. In cheating there is a concealment. Always remember this too. Whoever by concealing any fact believes, makes another person to and induces that person to deliver any property or to retain any property. That is cheating. So in every cheating there must be a concealment. You are lacking some keywords, those for which there is no substitution at all. Mischief, whoever intentionally or knowingly cause any damage or destruction to the property of the public or any other person, that is mischief. Character in criminal case. Character is what? Character in criminal case is relevant, but when evidence of good character is given by the accused, then that is bad character. In civil case, totally immaterial. Thank you. Don't give again. I have told you make brief answer. Brief answer. Sometimes you wait, trying to give answer, you are going something, leaving the track. Thank you. Please take care of this defect.
Yes, so good. I mean, it seems that you are thorough with the legal provisions and laws that you have studied. But sir has already told you, I'll not repeat, but yes, sometimes you need to answer to the point. You need not explain, because one thing is that you must know the panelists are much more seniors. It is admitted fact that they know the answer, they know the explanations. Okay, you need to be very brief. That is what I had made one point. And next is, need not speak so fast. You can just be a little slow. And okay, I'm not saying it's bad, but sometimes, you know, little answering in a, because you're good in English, you can answer the question, but maybe because of anxiety or because of expressing it in a very eloquent manner, you speak little faster, right? That may be, it's not bad, but just keep it in mind. Okay. And then when you have, you need to focus in those areas where uh, I just make the note, just a second, huh? Where your research, your because you're working or you're studying human rights, so it is expected that the current scenario with respect to human rights issues, judgments of human rights, uh, those questions will come. It is expected of you to answer those questions. Okay. Now, most importantly, what I have observed, what when you are giving your opinion, keep it to the last. This is the answer to, okay. And in my view, this is what. So while answering in between, if you give your opinion and then mix it with the statutory provisions, that looks like you're not answering or giving a lecture kind of thing. Okay. Again, I would say that that's not bad, but sometimes you never know which of the learned panelist will take it how. So it's better give the answer. Then further, if you want to give your opinion, then with the permission of the uh, panelist or panel, you can say that, sir, this is what my opinion, even if this is the provision. All right. Thank you. All the best.
Thank you, sir.
Thank you. Best wishes. Best wishes.
Thank you, sir. Thank you.
Thank you, sir. Sushrita, I I have said at earlier occasion also, I see you clearing it this time. Take it as a prediction. You are clearing it this time. After the 3 rounds of mock, I can with assurance say that you are clearing it. Having said that, there were some questions you couldn't answer, but yes, of course, you're not supposed to know every answer. The way you manage the interview, that's the most important part, and that you do pretty well. Okay. Other than the over explanation, sometimes that sir pointed out, you are doing really well. And 10 pillar order is an order when the plaintiff is permitted to enter into the land of the defendant and to collect appropriate evidences which are likely to be destroyed if not collected soon. So those are called Anton pillar order. And what else couldn't you answer? Nature of Indian secularism. I'm happy with your answer. Yes, section 27, the government part that is given in Article 111 and 112. Article 111 and 112 says suits by government. For that, any suit, it will be 30 years. So that by that logic, it is 30 years. Otherwise, section 27, nowhere it speaks. We just say that it's 30 years, not knowing where it is written. So that's the reason I wanted you to know this. Okay. And other than that, you are doing well. I don't see any problem. Detinue is when a property is detained unlawfully. Detained unlawfully, not a person. But when a property is detained unlawfully, and that is in fact kept by someone wrongfully, that is called detinue. And when it is converted, then it is called conversion. So that is called detinue and conversion. Okay, that has relevance with contract, specific relief, all of that it has. Okay, that's it. Thank you, Sushrita. Like, be calm like this. Yes, try not over explaining like Sir Gadar sir told you, Prabhu sir told you. Other than that, I think you're on the right track and you'll do well. Revise for the last few times that you can. Make sure that you read the newspaper well, and you'll be good to go. Okay. Thank you. All the best, Sushita.
Thank you so much.
Yes. Yes. We are now taking a break for 20 minutes. We'll assemble at 10:45 again. अरे बद्री दिसो काढला
बद्री ନାହିଁ ମୁଁ ଏକା ହିଁ ଅଛି ମାନେ ଲାପଟପ ରୁ ଗୋଟେ ଫୋନ ରୁ ଗୋଟେ
ଓହୋ ବଦ୍ରି ନାହିଁ ମତେ ଲାଗିଲା ବଦ୍ରି ଅଛି ବୋଲି
ନା
ଆଚ୍ଛା
ନା
ଆଚ୍ଛା
ନାହିଁ ସେ
ये ଝିଅ ପାଇବ 100% ପାଇବ
ହଁ ବହୁତ ଭଲ କହୁଛି ମାନେ ଫ୍ଲୋ ଭଲ ଅଛି ତାର ପୁରା
ପୁରା ପୁରା ପାଠ ବି ଜାଣିଛି ସବୁ ଜାଣିଛି ଏଇଟା ପାଇବ
ହଁ
ଠିକ ଅଛି ତାହେଲେ 10:45 ରେ ଷ୍ଟାର୍ଟ କରିବା ତାକୁ 10:40 ବେଳକୁ ଟିକେ ମେସେଜ କରିଦବା ଆଉଥରେ ଆଉ ସେ
ଠିକ
ଯୋଉ
ଅଛି ଠିକ
ଗ୍ରୁପରେ
ଅଛି
ତୁ ତାକୁ
ହଉ
ସେ ଜଏନ କର ବୋଲି
ଠିକ ଅଛି
ଓକେ
ହଉ